A lot has been happening these past few days. This is day 5 of the trial. Joining me right now, Tom Maronick Jr. and Frank Salvato, our legal experts for today, both attorneys in the area. Let's talk about what we just saw in the last few hours. We had a blood stain splatter analysis. Tom, do you want to talk first about kind of the key takeaways here?
Well, the expert was all over the map. She would describe something as a circular pattern and then repeat that and then say she couldn't make a conclusion on it. So she just seemed very, very disparate in her analysis. And I would expect that the cross is going to attack the science of it anyway, because blood splatter analysis is not the same as DNA analysis. So I think you're going to be seeing some of that when the defense has a chance to cross.
Frank, what about for you? You know, we've only seen the defense asking the questions, mostly the prosecution butting in here and there, but really not too much. And you kind of both commented on that as well. For you, what were the takeaways here?
I think the takeaways, first of all, the defense attorney did a wonderful job at limiting some of the questions that the blood spatter expert was about to answer. But we have to remember what the prosecutor is trying to do here. What the prosecutor is doing is to try to show that it wasn't Mr. Ryan on top of Miss Banfield with the blood coming on his clothes. Rather, it was Mr. Banfield, pursuant to the au pair's testimony, on top of his wife, and the blood spatter patterns are consistent with that scenario versus how Mr. Banfield is going to portray it, that Mr. Ryan was the one doing the stabbing. So there was some awkward questioning on direct testimony, but the import of that blood spatter evidence could be really, really critical in this case, because if the blood is on Mr. Banfield and not Mr. Ryan, then the prosecutor is going to argue that he was the one actually stabbing his wife, corroborating what the au pair told the jury.
All right, so a lot of new information in all of this, a lot of new information that we will probably get in the next few hours or so. You know, the prosecution led that line of questioning. Next, we're going to hear from the defense. If you're the defense attorney here, what are the first questions you're asking this woman?
I'm going to go after some of her certifications and qualifications. I'm not going to talk about the fact that she's not allowed to ask the questions, because he did not object to that. But I will talk about the science. I'll talk about where exactly she got her degrees, her information from, and then I'll talk about some of the holes in what she found. You couldn't determine this, you couldn't determine that. You said earlier you couldn't tell which stain was on top. It fits what the defense is trying to do, to find reasonable doubt, to poke holes in the state's theory of the case.
Yeah, one of the things that sticks out for me when I was listening back and thinking about what she had said was when she was asked about the sequence, and if she could tell the sequence of events of when the blood hit the pants, when it hit the shoes. For you, I know you mentioned as well, that was a problem when she answered that way for the prosecution. Can you elaborate?
Yes, she batted around. She didn't go direct to the question. She went into the analysis she'd have to do to try to find the answer, and then ultimately said, in this case, no, I can't tell. So if you're a juror watching that, you're saying she doesn't know what she's talking about. Yeah.
Frank, if you're Brendan Banfield's defense attorney here, what are the first questions you have coming out of this?
Having been in his shoes many times, it looks like he has been able to eliminate some of her ultimate conclusions in the case. You see that a lot of the objections were sustained at the bench. So Mr. Carroll has to be really careful at this point. I would expect a short and punchy cross-examination, because if he opens the door to some of the information that he has excluded, some of these ultimate conclusions about where the bodies were positioned, and is that consistent with the way basically Mr. Banfield has said it, or how the au pair has said it, if he opens the door to any of that information, the prosecutor on redirect is going to open the door and run right through it. That is going to be a real problem. So I'd expect this to be a very short and punchy, something based upon her certifications, the science. I don't think he's going to touch much of the factual evidence in this case. He's done a nice job at limiting it. He doesn't want to open that door.
All right, we saw a lot of images. Obviously, this is a very gruesome case, so we do want to warn you, some of the stuff you've been seeing and will continue to see will be gruesome. One of the other things that I noticed with her is that, you know, it was confusing. It was a lot of science speak. How do you kind of translate that for the jurors so they better understand if you are the prosecution? How do you make sure that the jurors aren't walking away more confused? You want to start?
I think that what the prosecution has to do is ask more follow-up questions, and I don't think they've been doing that. So to put that in different terms, you know, Ms. Dally Graff, can you explain what that really means? Can you give an example? And as long as she's able to sort of discuss it in a way the jury can understand, then that's fine. It does open the door to some defense objections if she goes too far, if she tries to get into beyond the scope of what's being asked. And that was one of the objections you heard from Mr. Carroll, that that's not the scope of the question. You've got to keep it to what is actually being asked. But I think the witness is describing things the jury doesn't quite understand. Okay, what's the significance of a circular pattern versus a non-circular pattern? She's not really explained that. And the jury's left wondering exactly what that means.
Yeah, and then the blood splatter, the blood smear, I think it's coming across a little confusing. Do you feel that way too, or do you think the jurors are smarter than we're talking?
Well, jurors are always way smarter than the attorneys, right? The attorneys always think they're the smartest ones in the room. Sometimes the judge thinks that, but usually it's just the attorneys. But it's actually the jurors who are the smartest ones in the room, and I think we, in the legal profession, underestimate how bright people are. In this case, slightly confusing just because of the awkwardness and the clumsiness of the direct with the objections. However, what the prosecutor, I believe, is going to do in closing is going to say, listen, if it was Mr. Ryan stabbing Miss Banfield, you would see the type of pattern on his clothing. It's not there. However, if it's Mr. Banfield stabbing his wife, you're going to see those types of patterns on his clothing. That is there. So they're going to try to tie it together in closing. They weren't quite able to do it with this witness. The judge limited them a little bit, but in closing argument, all holds are off, and I think they're going to be able to tie some of the blood spatter evidence together nicely if they can do it.
Okay. So on Thursday, the prosecution said that they only had 2 more witnesses to call. This is their first witness. We expect to hear from 1 more. We are hearing it may be a family member of Christine Banfield's, and it is expected to be emotional. Do you think that the prosecution has moved too quickly? We are on day 5, if you count jury selection as day 1. I know that's been a whole debate, but we are on day 5 of this trial, and we've already heard from the star witness by the prosecution, and now they are expected to wrap up either today or tomorrow. For you, are they moving too fast?
A little bit.
Okay.
I think that they're not explaining enough. Everything that Frank said a few minutes ago about the importance of the spatter, where it is, whose clothing it's on, the patterns, I think they need to spend a lot more time on that, because if that's going to be your big conclusion at the closing, then you've really got to get to that. And obviously the judge is going to eliminate some of the questions, keep out the questions that are leading. You've heard a lot of sustained objections on that, but there's ways around that to build a foundation, to talk about what that can mean and how you get there. And I think they're just glossing over things, and the jury might get confused.
What about for you?
It's an interesting situation because probably what the judge said in the beginning was, ladies and gentlemen, during jury selection, you're looking at about a 3 or 4 week trial. That's going to now turn into, hey, ladies and gentlemen, I think she'll probably phrase it as, we've got good news. This case is moving a lot quicker than we anticipated. Now, will the jury give the benefit of the doubt to the prosecutor and say, wow, you've got a great case and you've moved with such alacrity that the case is going to finish up soon? We really appreciate that. Or will the jury sit back and say, well, wait a second, I thought I was going to hear 2 or 3 weeks from the prosecution. Now it looks like they've cut down their evidence to what, 3 or 4 days? Like, how are they gonna take that? So it'll be interesting to see, based upon how much the prosecutor has cut down their case time-wise, will the defense also do the same? Or will the defense, if they do call a witness, will they call a bunch of witnesses to really overwhelm the prosecutor in terms of time? Very rare that the defense case takes longer than the prosecutor's case. I'm not sure what Mr. Carroll's going to do here yet. Let's see how those last couple of witnesses go. But this case is moving pretty quickly. We'll see which side that benefits.
All right, let's get back to that in a minute. We do want to get out to Matthew Torres. He is outside the courthouse for us. He has been in the courtroom all day. Matthew, I'm here with two of our legal experts, Tom Maronick Jr. and Frank Salvato. But we want to ask you, we've been talking a lot about how this last witness testimony, it's been a little confusing to follow. What has been the reaction that you've seen on the faces of the jurors as this is all playing out today?
There was a moment there where it looked like they were getting restless, especially right before we went on that first break when the prosecution was really just trying to set up all the technical aspects as far as their evidence and being able to show the markings on one of the photos that this expert said on the stand. You can see they started even looking at us at one point. One of them really has been feverishly taking notes. Some of them were not. Some of them started glancing our way. And so that's kind of been consistent throughout this whole morning and part of this afternoon, especially when they go into painstaking details as far as each blood splatter, each drop, each transfer of blood. That can be somewhat confusing to follow. We can see what the prosecution is trying to argue here, that the bodies were moved. Allegedly, Banfield may have dropped the blood of Christine on Joseph Ryan. So all that, we can see what they were trying to argue and trying to bring up. Of course, the ongoing objections and the judge sustaining those objections from John Carroll really has taken helm as far as today. Jurors taking notice of that as well. There was a moment when they initially showed the picture of the right arm of Joseph Ryan with the blood, the wet blood on his hands. We do know there appears to be at least one relative of his sitting in front of me and potentially two other relatives or friends of Joseph Ryan as well. One of them kind of sat back a little bit when they first saw that picture. Of course, seeing blood like that for the first time, knowing that it belongs to potentially your friend or relative, that was a little jarring for that person. I also wrote that the judge, you could really tell when she is anticipating an objection from the defense. She's almost expecting him to object, where she's really paying attention to the line of questioning from Jenna Sands, the deputy Commonwealth attorney, and in doing so, she almost cocks her head a little bit and looks at defense attorney John Carroll, anticipating him to do that. And in doing so, it seems like that was the case, and she, in response, for the most part, have sustained a lot of his objections. And so for us, from those watching from the gallery, it was a somewhat slow start, somewhat bumpy start from the prosecution. Interestingly, you guys mentioned that this has been going very quickly, at least for the prosecutor side. Today, knowing kind of how long this has taken, it kind of slowed that progress. But as Katie mentioned there just momentarily, a relative of Christine Banfield is supposed to be the last witness for the Commonwealth. We understand it is her father who is expected to testify.
Okay, and Matthew, we've been hearing that obviously as well, but have you seen her family in the courtroom at all? I know early on you said that some of her family was there. Was her father there, her mother there the whole time?
Her mother is there the whole time with, we would presume, other relatives. So they've taken up pretty much the front bench to the left side of the courtroom. From my understanding, since the father is supposed to testify, I believe we just shared an elevator with him just coming down here. He has not been in the courtroom during this time, but as we mentioned, every time there been a photo of a crime scene, blood that belonged to Christine, you don't really see them looking at the screens when they do show those photos to us in the gallery. They just keep their gaze, their direction, just looking straight forward during that time. But they are there, and for the most part, we see more of her family side there than Brendan Banfield or Joseph Ryan's.
All right, thank you, Matthew. And as you're looking around the courtroom, I know, on some of the days, specifically when Juliana was testifying, there were pretty large crowds there. We're not able to see into the room. Are there crowds there today? What is kind of the atmosphere like in there?
As far as the attendance, it's probably the same, maybe what we saw from Thursday. Juliana being obviously the star witness for the Commonwealth, there were more people from the public that were there. It's kind of thinned out a little bit. We see attorneys, we obviously see family members and media there as well. I would say there may be 3 to 4 people who are from the public just wanting to know what's happening. Interestingly, each day we see someone new taking notes, but certainly not as much as what we saw from the first 2 days of testimony.
Okay, Matthew, thank you. And I know you mentioned we're expecting one more witness from the prosecution. Do we know at this point how many people are still expected to testify for the defense?
Last I checked, at least just with the subpoena list that we were able to get our hands on, there were close to 70 names listed for the defense. Clearly, a lot of these names, some of them have already testified, from detectives to experts. Even the window pane guy that testified last week, they were already listed under this. So it's going to be interesting to see who they actually bring on, who they'll have for redirect. One name that also stuck out to me was one of the investigators, the head of the domestic violence division in FCPD, also dealing with juvenile-related crimes. So potentially they could be talking about the one charge related to child neglect. That is the 4-year-old child then of Christine Banfield and Brendan Banfield whenever these murders happened. So who knows how many will actually go through that, but certainly a longer list versus the Commonwealth's.
Yeah, and Matthew, that's interesting that you bring that up, because I believe we've talked a little bit about how to this point it hasn't really been clear how they're going to, get a conviction, if you will, on those charges for child abuse. We really haven't heard much about that. I would like to bring our legal analyst back into the conversation, Matthew. I don't know if you want to stick around, but, why haven't they brought up the child abuse charges to this point? Do you want to start, Frank?
Well, I think we talked about this a little bit in the beginning of the trial. There has been some testimony from the police officers that the child, I believe the child was 4 years old or so at the time, was in the basement at the time that this took place. Some interaction between the police officer and the child to make sure the child was safe. That's probably all they need to support that charge under Virginia law. Again, I think that part and parcel of bringing that charge was to, for lack of a better term, to dirty up Mr. Banfield as much as possible. Not like the charges themselves aren't terrible enough,
right,
but now the child was at the house. That is obviously the least important charge in this case. So we have heard enough under that Virginia statute for there to be a conviction. You have a child in the house when there is a double homicide committed by your parent. That's enough. I think the prosecutor isn't really going to focus too much on that. Maybe they'll call one additional officer or witness on that charge, but I would anticipate the jury, if they convict him of the murder, they're certainly going to say, listen, and your kid was there. That's just going to be an added charge.
Yeah, and I'll direct this question to you, Tom, but Matthew was talking about how he recognized one of the names on the defense's subpoena list of potential witnesses. We have a list of dozens of names, so we don't know exactly who they're going to call and who they just got cleared to be allowed to call. But he recognized one of the names as somebody who's part of the child abuse squad in some capacity. If you're the defense attorney here, why would you bring somebody up to talk about that when we haven't seen the prosecution talk about it much?
Well, you don't have to call that witness.
Okay.
You have that witness there in case the prosecution wants to bring up that issue. To what Frank said, I think it's sort of owning a steakhouse and focusing on how good your salads are. It's really that's what the prosecution's doing. They're focused on this murder charge. They're focused on that, the 2 charges technically, and they don't want to distract the jury. But They will hammer away that the law is met, that the standard is met, and then if the defense spends time on that, I actually don't think that's a winning strategy to focus on that when you've got to get him acquitted of murder first.
Right.
But it's good to have that there in case you need it.
So probably just on standby at this point, but I guess we will see in the next few days. I do want to do a little bit of a recap for everyone tuning in. You know, this is the trial for Brendan Banfield, and I would love if we could play some of the video of the opening statements. We're taking you back to exactly a week ago. You know, the trial started at 10 a.m. last Tuesday, and by 10:35, they had wrapped up the opening statements. If we're able, I'd love to play you kind of a recap, some of the highlights of those opening statements.
The Commonwealth versus Brendan Banfield. Mr. Banfield's present, the Parliament's attorney, and the Commonwealth is present.
We're here today because Brendan Banfield, the man seated behind me, killed his wife, Christine Banfield, and another man named Joseph Ryan.
The murder of Christine Banfield by Joe Ryan occurred February 24, 2024.
They sneak up the stairs to the bedroom where they hear Joe Ryan and Christine. Brenden enters the bedroom first, shooting Joe in the head, picks up the knife that Joe had brought, and stabs Christine repeatedly in the neck. He directs Juliana to shoot Joe a second time with her gun. Brenden spends the next several minutes manipulating Joe Ryan's body, in the process leaving Christine's blood on Joe's hands and pants.
The arrest of Juliana Peres Magalhães took place in October. The whole reason she was arrested was to flip her.
Anything you want to say?
You won't hear any dispute as to the relationship between Brendan Banfield and Juliana Peres Magalhães. But there's an awful lot more to look for, ladies and gentlemen.
The blood puts Brendan Banfield standing over Christine, stabbing her in the neck until she died. Well, Juliana presents us with the narrative. It is the blood evidence that you can rely upon without a doubt.
Digital forensics doesn't lie. People lie. And there are going to be plenty to see.
All right, so those were the opening statements, the highlights, if you will. It was only 30 minutes total between the two of them. I'd like to start with you, Tom. We talked about this last week quite a bit. Tom, were you surprised at how quickly they got through those opening statements?
I think when you do opening statements, you want to lay a roadmap. You don't want to put your whole case out. You simply want to lay a map of what you intend to prove if you're the prosecution and if you're defense. Start poking holes at your theory, why your theory of the case will poke holes at the prosecution's theory. So I think that was probably what they wanted to do on both sides. The prosecution had a goal in mind, and it's to start dirtying the image of Brendan Banfield. And that's exactly what they were doing. They talked about the affair. They talked about how this was plotted. They talked about how all the dots will connect. And then the defense said, there's lots of holes to this, and they rely on witnesses you can't trust and science you can't trust. So I think that both sides sort of staked their claim to what they intended to do in the trial.
And Frank, for you, you know, we talked about this last week. We were surprised. I do want to be clear, the prosecution has at least one more witness that they're going to call, and the defense is going to wrap up with this first witness. Do you think the prosecution has fulfilled what they said they were going to fulfill?
I think they fulfilled the outlines of what they said that they fulfilled, that they were going to fulfill. The question is, the au pair's credibility was really impacted by the cross-examination that Mr. Carroll did. Did they fulfill all of their promises with that type of testimony? That remains to be seen. Again, my philosophy on opening statements is probably a little bit more expansive than I think you saw from the lawyers here. I think in opening, if you feel that you are going to be able to prove a specific fact in terms of her credibility or on the prosecution side and in terms of the blood spatter evidence or something like that, you have to put that out there directly to the jury, because then the jury, as they see the evidence, they're like, wow, that defense attorney was absolutely correct. We just saw that. Or that prosecutor was absolutely correct. We are now seeing exactly what they told us in opening. So I was a little bit surprised at the brevity of the opening statements. I would expect closing statements to take quite a bit longer.
There's one other point to be made on that. You don't want to say you're going to do something and then not do it. We talked about the brevity of the trial. The prosecution needs to say everything that they put out in the opening, they're going to show in the trial. But if they leave something open, the defense can come out and say, they said they were going to do this and then they didn't do it. And vice versa. If the defense says, this is something that we're going to poke holes at, and then they don't do it, the prosecution will, of course, point that out on the other side as well.
Do you think there's anything the prosecution has failed to do, given that we still have one more witness to take the stand at least? Do you think they've failed in any capacity?
I don't think they've failed, but I think they could have been clearer on some points.
Okay.
And without the completion of the witness testimony, it's tough to say they overall failed.
Thank you both. After the opening statements, we also heard from several witnesses. Right off the bat, we heard from crime scene investigators, we've heard from forensic experts, but one of the very first day people to take the stand was Juliana Peres Magalhães. We do want to take you through some of the testimony that we heard the last week, but first we want to let you know that we are going to be taking some questions for our legal experts here, and if you would like to ask a question, if there's something you've been wondering, feel free to ask it. All you have to do is text 202-895-5599. That is 202-895-5599, and we will try to answer those questions in just a moment. But first, I do want to give you a quick recap of some of the testimony we heard last week.
I need help. My friend, he just was stuck in the knife now. He's bleeding a lot.
My name is Brendan Banfield. I'm a federal agent. This is my house. There's somebody here. I shot him.
What did you see when you went into the bedroom?
At first glance, I saw a female that was nude. She was covered in blood, with a gentleman standing over her with bloody hands.
Who is the shooter? Who shot who?
Brenden, he's an officer.
We first asked, does he have a pulse? He did follow up with, is she breathing? Or is she going to be okay? Is what he said.
What's going on this morning?
Brenden said, no, police don't drop the knife. And he was saying, I'm going to kill her, I'm going to kill her. And I don't know, he started stabbing her. I think Brenden shot him.
Initially, we walked outside, allowed the first ambulance to leave, and then Mr. Banfield was taken into a second ambulance.
What, if anything, did you see him do while you were in the hospital room with him?
He washed his hands.
And before he washed his hands, had anyone swabbed his hands to preserve samples of blood that were on his hands?
No, we're trying to be empathetic. Yeah, no, I understand. Was there anybody who told you not to do that? No, sir.
That's based on a penalty of law.
Yes.
Thank you. Now you can have a seat.
What I told the detectives that day, it was the version Brenden had told me. Brenden said he yelled, police officer, and she yelled back at Brenden saying, Brenden, he has a knife. That's when Brenden first shot Joe. He got on top of her, and that's when I first saw him stab her with a knife. I just start telling him his movie is behind you, and that's when I fired the shot too.
Did you see him interacting with Joe or Christine after you shot Joe?
Well, he was still stabbed in Christine, and he got her blood, a handful of blood, and he starts dripping on Joe's body.
You're asking the ladies and gentlemen of the jury to believe that you came out during that time frame because you wanted the truth to be known versus any time the year before that.
Well, the fact that I took a year to accept my plea, it does not mean that I didn't have anything to tell the truth before. I had a video call with the producer who works with Netflix, and they want to make a movie or documentary about my case, and he explained in terms of compensation. So they were thinking about $10,000, but I want to negotiate. I want more than this.
You were charged with murder because you shot someone. Am I wrong?
No, I'm not.
And so why would you deserve something because of that?
Not because of that.
I didn't say that I deserved something because of
Okay.
what I did.
I didn't hear any details, so feel free to tell me why.
I'm saying for after, when this is over, for me and my family. And again, for everything we've been through.
All right, some powerful testimony there just in the first week. I think some of that was the first day of actual testimony in this trial. Again, we are going to be taking some questions here for our legal experts, and we want to hear your questions. So if you'd like to submit a question, all you have to do is text 202-895-5599. You can see it there on your screen. We are going to be having your questions answered by our legal experts here live as we get them. So Frank and Tom, I do have some questions already that have been coming in, people texting them in. One of the questions that stood out to me, and we've talked about it a little bit at different points, the importance of Brenden taking the stand. Will he take the stand? And, what are the pros and cons? Why don't we start with you, Frank? What would be the pros of Brendan Banfield taking the stand here?
The pros of Brendan Banfield taking the stand.
Are there any?
Very limited.
Okay.
I would anticipate there is a close to 0% chance he takes the stand. There's just too much information, too many statements, too many inconsistencies for him to take the stand. Now, certainly that is the client's prerogative to do that. It seems like he has a good relationship with his defense attorney. I would anticipate that his defense attorney has advised him not to take the stand, especially how well the trial has gone from their perspective. So the pros of him taking the stand, very limited. Now, he does get to tell his side. And when you're in the courtroom, if you see a juror or several jurors that are staring at your client or looking like they're going to convict them, then you want to put your client up there on the stand to certainly tell his side of the story. He may overrule his attorney and decide to take the stand.
Okay.
But I think there are very limited upside to Mr. Banfield to take the stand. The cons are just way outnumber the pros, in my opinion.
Do you feel the same way, Tom?
I do.
Okay. Let me ask you a follow-up then. What are the cons, like the biggest red flags to him taking the stand for you if you're his attorney?
Well, it's a standard of law. Defense is there to show that there's reasonable doubt. Defense doesn't have to call a single witness, ask a single question. Of course, you're going to do those things, but you don't have to. You just have to show that there's reasonable doubt to what the state or the Commonwealth in this case is trying to prove. And if they can't do it, then you win. The jury's required to acquit at that point. But if you put your defendant on the stand, at that point, the jury tends, at least in their minds, to flip the burden. They start poking holes at what he's saying. Well, he's not credible. He's not telling the truth. And then they lose focus on what the standard of law is, and you have to try to bring them back in, and that's very difficult to do. So I would agree with Frank. I think that's about a less than 1% chance he takes the stand.
We've seen him taking a lot of notes. We've seen him making eye contact with various people. From our standpoint, we can't tell who he's looking at, but it looks like he's looking at the jurors. It looks like he was looking at Juliana when she was speaking, and he's holding that eye contact with whoever it is he's looking with. Do you think there was a conversation? I'm sure there was. What was the conversation that was had before between John Carroll and Brendan Banfield before they walk into that room each day? Do you want to start, Frank?
As we saw in the beginning, Mr. Banfield was kind of fidgety. His body language wasn't great, in my opinion. Covered his face a little bit, lots of note-taking, kept passing notes to Mr. Carroll, suggesting what questions to ask, the way I saw it. However, after Mr. Carroll began to pick apart Ms. Magalhães' testimony, and he did that over a course of a day, just in a brilliant way. Especially about her selling her story and what she's been through and that she's really the victim in all of this. He did a really masterful job on that. Mr. Banfield seems to have relaxed a lot, realized that Mr. Carroll full well knows what he's doing, and he seems to be backed off of his interactions with Mr. Carroll. So now he's more confident and he's looking around the room, he's looking at the jurors, he's looking at family members. I think he's feeling that this trial has gone as well as it could have been. Now, Jenna Sands, they're wonderful prosecutors, and they've been doing a great job with what they have, which is still a substantial case. So we'll see what they have left. But I think Mr. Banfield now is feeling his body language. You can see it. Like, this is going pretty well, and his attorney is doing a darn good job.
What about for you, Tom?
I agree with that, but I would also say I think he's been coached to do some specific things, and that is, if you watched the Johnny Depp trial, Johnny Depp, when Amber Heard was on the stand, could have looked up, could have reacted. He was there taking notes, keeping his head down, staying engaged, but not doing anything that could deflect the attention. And I think that he's done a good job of that. He's not done anything that would throw the train off the tracks, and that once again speaks to his lawyer and he interacting correctly, coaching correctly, that you don't want to become the focus of this trial. He was nervous at the beginning, he relaxed, he sort of got into a flow, because once the trial moves on, at that point it's more systematic. You sort of understand that it's part of a process.
Right, and you mentioned the word coaching, and I think we've seen a lot of coaching from Brendan Banfield, from the people taking the stand. How much coaching is happening as two people who are probably coaches at certain points when you're, at a trial? How much coaching is done leading up to the trial? Do you want to start, Tom?
I'll say we always coach on demeanor. We want our clients to come in wearing a suit, to act professionally, to be attentive but not emotional, just to be invested in the case, to show that you are the innocent person that you are and remain throughout the trial. Obviously, some clients like to be more involved. They like to write notes. They like to tell us something that they think is important. And of course, we lawyers look at those notes and see where they're going. But we just hope that they don't veer into trying to tell us how to do our job, because there's a fine line between a helpful client and a client who's trying to overtake the trial.
And I think the jurors can really see that when you're passing notes, as we saw. I think, we both, all three of us, noticed right away, oh, Brendan's passing his attorney notes. You mentioned to me last week a comment about John Carroll's suit one day. Can you talk about the outfit choices that were made? Whether it's Juliana's outfit choice, her hair was a different color. Were choices made there, and were choices made with Brendan and the outfits on the attorneys here?
There is a lot of coaching going on, and I think that's good. As we talked about last week, only a foolish attorney would call a witness and just ask questions and have no idea what that witness is going to say. I've certainly had a lot of federal cases where I've prepared clients and witnesses for hours, for days, sometimes multiple times. There is an opportunity sometimes to have a colleague cross-examine your client if they're going to take the stand. So there is a lot of coaching going on. There's also, as it gets down to the finer details, there's clothing choices. There's certainly the way you want to portray Ms. Magalhães from the prosecutor's perspective. Could have been completely innocent, but it seems like she came in to portray herself as kind of young, which she is, naive, unsophisticated. Now we saw that profile kind of deteriorate a little bit as she became testy and confrontational with Mr. Carroll. When he cross-examined her, and I'm not in charge of John Carroll's clothing attire, but he certainly came in with a very light suit, very gentlemanly, very scholarly.
You called it his trust suit.
His trust suit.
Yeah.
A friend of mine calls it, I'm going to wear Trust Me Brown today. And it's just the perception. You don't want to come in wearing a black suit with a black tie and really be ferocious. He came in with a lighter suit, lighter demeanor, but then his words were ferocious. His cross-examination was ferocious. And as we talked about last week, jurors tend to like the lawyers. They're still unsure about the witnesses. So when the witnesses start to give the lawyers problems, then the jurors really start to dislike that witness. And he did a really good job in a very trust me, light suit as kind of dismantling her testimony. And we'll see how the jurors actually react to her. If I'm doing the closing argument, my first line is reasonable doubt walked into the room when Juliana Magalhães walked into the room. I think that's what you're going to see from Mr. Carroll. Very direct, good points right away, and sort of just reinforcing what the jurors have already seen.
And you mentioned a similar closing statement to me as well. What would your closing statement be here?
I would talk heavily about the standard of law. I would compare the different types of law that you have and what that standard is, and indicate that that's still not enough to prove reasonable doubt. To prove beyond a reasonable doubt, I'm going to say, but essentially that's what I like to do. I focus on the standard of law, and then I like what Frank had to say about reasonable doubt walking in. I would say, and if that wasn't enough to show you that there's reasonable doubt, then you look at the science of this. They said the science was going to prove something, and in fact, it's helped our case. It's helped the defense's case.